Hello, my name is Assad Hafeez, immigration attorney on behalf of Legal Strategies Company. My office is located here in Sacramento, California. I am practicing in the Ninth Circuit. I want to continue my series of giving you quick immigration case law updates. I primarily focus on the Ninth Circuit, but I also will mention other notable cases from other circuits to illustrate other key immigration concepts. And with no further ado, let me get right into it for your educational benefit. First case is out of the Ninth Circuit, U.S. versus Ochoa Oregel. And this was decided August 2nd, 2018. It reversed a conviction by an unlawful re-entry into the United States of a green card holder, a legal permanent resident. He argued that two different previous removals were fundamentally unfair and violated his due process, and therefore couldn't serve as a predicate removal for the purposes of an unlawful re-entry conviction. The Ninth Circuit agreed with his position and reversed the conviction. So you can challenge a previous removal for the purposes of an unlawful re-entry conviction. He was able to establish that his rights were not honored. The next case is called City and County of San Francisco versus Trump. This is a big case. It was decided August 1st of 2018. Trump's presidential executive order withholding federal grants from sanctuary cities. This is a very timely issue. It was ruled unconstitutional. California municipalities, local authorities, brought this suit arguing that the order violated the principle of a lot of constitutional law here. Separation of powers, along with the spending clause, which vests exclusive power in Congress, not the presidency. The Congress to impose conditions on federal grants. The Ninth Circuit agreed and affirmed summary judgment in favor of the California municipalities. However, the panel vacated the nationwide injunction based on an absence of specific findings justifying the broad scope and remanded for further findings. So let's stay tuned. This case may make its way all the way to the United States Supreme Court, and it's going to decide this debate over sanctuary cities, local authorities, and their extent of participation with federal immigration authorities. Federal grants for counties, entities that do not participate with ICE. So next case is out of the Third Circuit, August 1st. It's called Fan versus Attorney General. It vacated an administrative decision that ordered a green card holder removed from the U.S. for having committed an aggravated felony. But the allegation involved a financial services firm, and he pled guilty to a securities law violation. So does this amount to an aggravated felony? He contested it, and the Third Circuit agreed with him that it does not amount to an aggravated felony. Therefore, he should not be removed. It is worth challenging a finding of aggravated felony depending on the kind of criminal history alleged. It might not amount to an aggravated felony, and that's what this gentleman did. The Third Circuit agreed and remanded it back to the Board of Immigration Appeals. Next case, Ortega versus Maricopa County. This is July 31st, 2018. Ortega versus Maricopa. It affirmed a second supplemental injunction barring the Maricopa County of Arizona from racially profiling Latino drivers and passengers under the guise of enforcing federal immigration laws. In challenging the second supplemental injunction, this is the second one, the county argued that it was not authorized under Arizona law to fund compliance with the injunction. Ninth Circuit rejected the county's arguments. Maricopa County in Arizona has to get in line and follow the previous order. They need to stop racially profiling under this decision. Next one is Ninth Circuit, Guo versus Sessions. This is the 30th of July. It reversed the denial of a Chinese citizen's asylum claim. He alleged he would be persecuted for his Christian beliefs, and basically the BIA, the IJ, immigration judge, and the Board of Immigration Appeals did not agree. However, the Ninth Circuit Court of Appeals found that he did present compelling evidence of being persecuted for his religious beliefs back in China. He was entitled to a rebuttable presumption that he would experience future persecution if returned to China. So he is entitled to that rebuttable presumption. Sometimes the immigration judge and Board of Immigrations gets it wrong, and then you have to take it to your local circuit court of appeals. Next case, Frimmel Management LLC versus United States. This is the 26th of July, 2018. This involves the suppression of evidence, fruit of the poisonous tree. If you have officers doing an improper investigation and they violate privacy, Fourth Amendment rights, and they obtain evidence and they want to use that for an immigration prosecution against a company or against individuals, then you can have that evidence suppressed where it cannot be considered. This evidence presented by ICE, Immigration Customs Enforcement, showing that an employer hired undocumented workers must be suppressed pursuant to the exclusionary rule. This is evidence law here, because ICE initiated its investigation after the Maricopa County Sheriff's Office conducted illegal raids of 2 restaurants and forwarded information to ICE. Agreeing with the employer, the Ninth Circuit reversed and remanded the administrative ruling denying suppression of ICE's evidence. So the Ninth Circuit agreed, wait a minute, no, that evidence does need to be suppressed. An appeal to the Ninth Circuit Court of Appeals may accomplish it. And that's what happened here on the 26th of July. Next one is another Ninth Circuit case, Allen versus Milas, the 24th of July, 2018. It affirmed the denial of a mandamus writ that would compel a U.S. consulate in Germany to issue a visa sought by a U.S. Army officer for his German citizen wife. In denying the visa, the consulate found the wife ineligible based on her past criminal convictions in Germany. In affirming the denial, the Ninth Circuit held that the Administrative Procedures Act, on which the officer relied upon, provided no avenue for judicial review. While a court can review the denial of a visa for constitutional error without a facially legitimate reason, that wasn't the case here. So you need a lack of a facially legitimate reason to find a constitutional error for judicial review. Anything else is not going to qualify. That was decided the 24th of July. All right, and that's it for today. This is a bit of an early August 2018 review of recent immigration cases. Again, my name is Assad Hafeez. I'm an immigration attorney practicing out of Sacramento, California, Ninth Circuit. I can be reached at 916-836-5755 for any of your immigration questions. If you or a loved one are in need of immigration services, talk to me, an immigration attorney that is staying informed about the latest immigration updates. I appreciate your time and stay tuned. I will continue this series so that we are all up to date on immigration law. Thank you for your time.